Hey there, I'm Rachel Demarest Gold, and I'm Director of the Employment Law Practice here at Abrams Fensterman. I write a column for AM New York Law, and I want to take a minute to talk about my recent piece on DEI. I think it's important for people to understand a few things about this ongoing conversation. First, DEI is not affirmative action. Affirmative action was first established by executive order by JFK in 1961, where he said that people had been denied opportunity in employment long enough and that he expected the government and other employers to take affirmative action to address that situation. Affirmative action was codified in the Bakke decision in 1978, when the Supreme Court said that it's okay to treat people differently based on race, even though the argument was it was contrary to the Constitution, if the preference was based upon making up for certain consequences of past discrimination. It's been used to give people opportunities in the workforce. It's been used to give people opportunities in education, and it's been used to diversify a slew of institutions across our country. It's also the very premise that was overturned by the Supreme Court in the Harvard and UNC cases in 2023. DEI is something else. The letters stand for diversity, equity, and inclusion, but unlike any legal premise, DEI is an umbrella term for programs and initiatives that focus on bringing a variety of perspectives to the table and making sure that everyone at that table feels comfortable enough to participate productively and effectively. That's all it is. It's not a mandate. It's not a pie where some is taken from one for the benefit of another. It's just a framework. And quite frankly, in a market like New York, if you don't look to bring a variety of angles to the table, you lose market share. So not only is DEI not a legal mandate, it's actually an essential element of any business development strategy. And the federal government's use of the UNC and Harvard decision goes far beyond any legal precedent set by those cases. What do I mean by that? The 2023 decision said universities cannot use race as the only basis for deciding a person's admissions application, nothing more. Nonetheless, within days of the decision, senators were sending letters to private businesses threatening all of their DEI initiatives, and the Small Business Administration was forced to rework its loan applications and criteria. Since January of this year, executive orders have been passed, no fewer than 13, that eliminate protections and requirements across the board that deal with initiatives that incorporated DEI into federal programs. The EEOC, established as the Equal Employment Opportunity Commission, has changed its mission statement, whereas they would focus on race, religion, gender, and other protected characteristics, and how people who fell within those categories were being discriminated at work. What they now want to focus on is what they are calling anti-American discrimination, programs where people from places outside of the country are getting benefits at the expense of American workers. They've defunded programs that were meant to address these disparities. They've changed languages across their website, and they've been renaming landmarks and vessels. The practical meaning of all this in New York is, however, not quite as drastic as what is happening on the national level, and I think that's important for people to understand that too. When you file with the EEOC, you are also filing under state and local laws for any permission you may need to file a case in those venues. The same works in the reverse. If you go into your local county, whatever it is, civil rights office, human rights office, and you file a complaint with them, it is a co-filing with EEOC. The same is true with the New York State Division of Human Rights. I suggest that people file with their local and state agencies where they're going to get a faster turnaround. They will not have to wait for an intern appointment. And quite frankly, even if you don't file under the federal laws at all, there are no damage caps under the state laws. So unlike the federal law, you'll be able to get punitive damages and compensatory damages that actually match your losses. For employees, if you have a discrimination matter, after you've addressed it internally, if you feel as though you still need to file a complaint, go to your county authority or local office for State Division of Human Rights. Again, they're still processing everything, the damages are greater, quite frankly, they can adjudicate the whole thing without going to court, and the standards are still the same under the state and local law. For employers, things are actually going to probably get a little bit more difficult. The shifting standard nationally will mean, like the last time we had the same federal administration, that there will be increased enforcement here in New York. The budget already granted sheriff's powers to the Commissioner of DOL, and there is currently a bill in committee called the Empire Act, which would empower private individuals to bring wage and hour cases when the government doesn't have the resources to do so. So, what do you need to do? Make sure that your training is up to date. Every employee, no matter how large the workforce, is required to take harassment training every year. Make sure your records are up to date. Make sure your handbook is current and distributed. Make sure all mandatory posters are hanging at your work sites. Make sure if you get a complaint that a thorough investigation with follow-up is done. And as always, please reach out if we can be helpful. Thank you.